Hey civic students, this is Miss Drake coming at you with steps to a criminal case. I hope you guys are still doing well this week. We're working on sources and types of law, and one of the types of law that we have gone over in a previous presentation is criminal and civil law. So this week I just want to tackle criminal cases. After spring break we can take a look at civil cases. So I'm going to go over these notes in particular, and then you're going to have an activity to do after we are finished. Just like before when we were looking at sources and types of law, we're going to do a Quizlet. And the main reason I'd like to do a Quizlet this week, or two Quizlets this week, is to really get you very comfortable with terminology. I'll be honest, the judicial branch is probably the hardest branch of government because there's so many terms, even though really in Article 3 in the Constitution it's the shortest branch of government, but there's a whole bunch that goes on in the judicial branch in terms of interpreting the law. Really, the judicial branch is your last line of defense for your rights, especially as we're talking about criminal cases. Remember, in a criminal case, you could be deprived of your natural rights of life, liberty, and pursuit of happiness. So it's incredibly important that these steps are applied equally to everyone. That's rule of law. And so after you are finished with this particular lecture, you'll see at the bottom how you can access the Quizlet assignment. So jumping right into a criminal case, let's talk about the two main types of crimes that can be committed. And remember, a crime is where you break a law. And so the two main types are felonies and misdemeanors. Guess which one's worse? It's felonies. So felonies are violent crimes and major property crimes. So violent crimes are those like you see on your screen. Homicide, which is basically murder, first degree, second degree. Everybody asks what's the difference between first degree, second degree, and is there a third degree? The first degree murder is premeditated. It's actually premeditated with malice aforethought. You planned it out and you intended to kill someone and you did it. Second degree murder happens basically just in what we call a crime of passion, in a moment. That where you, for example, get into a fight with someone and you meant to hurt them, but you hit them so hard you kill them. Well, that's an example of second degree murder. You don't plan to kill somebody, but your actions mean that you do. There is no third degree murder, but there are varying degrees of manslaughter, and that's accidental killing of a person due to negligence, that you did something wrong, that you shouldn't have done, that you knew better than to do. Another type of violent crime is an assault. That's an intentional physical injury or threat of injury of a person. And rape and kidnapping are considered to be violent felony crimes. Property crimes like larceny, which is just a fancy word for stealing or theft. But the value has to be over $1,000 for it to be considered a felony. If it's under $1,000 or $1,000, then of course it's going to be a misdemeanor. And then you also have arson. Arson is also considered to be a felony property crime, which of course is setting fire to something, a building, whatever the case may be. A major indicator, like we were talking about with sources and types of law with that presentation, is the if-then scenario. If you break this law, then you get this punishment. So in this particular case, in our criminal justice system, in our code, our law code, a punishment for a felony can be anywhere from major fines and even probation. And by the way, probation is where you're going to be watched by the law enforcement agencies and the court for a certain period of time. And you can also have 1 year or over prison for a felony. And that's called short-term or long-term incarceration. So those could be punishments for a felony. And then let's talk about misdemeanors. Misdemeanors are generally non-violent crimes like disorderly conduct. You acting all crazy out in public or something like that. Drug possession to a small extent. Now we did watch the video where in California the guy who was selling marijuana, when we talked about federalism, he could have gotten the death penalty for trafficking so much marijuana. So we're talking about small drug possession and simple assault. For example, if you put your hands on someone but you don't hurt them to a large extent, like if you slap someone, for example, that is simple assault and a misdemeanor. Property crimes for misdemeanors include larceny under $1,000. And I'm throwing out an example. There are a lot of other different examples, like graffiti. Now, it can be a felony depending on the severity, but like graffiti could be an example of a property crime misdemeanor. And then for the if-then scenario, if you commit a misdemeanor, then your punishment can be anywhere, again, from fines and probation, which are going to be less, of course, than a felony, or a prison sentence of under 1 year in prison, which is short-term incarceration. And incarceration just means you're going to be going to prison. Now, speaking of that, it's not on your screen here, but a lot of students use jail and prison interchangeably, and really they pretty much are the same reason they're used for incarceration. But a jail, every county has a jail. So the county seat, or basically what's the capital of each county in North Carolina, has to have a jail that's used for holding people who are accused, waiting for a trial, and for short-term incarceration. In prisons are used for long-term incarceration, like the major one in North Carolina is Central Prison, which is located in Raleigh. And what I have here is at the bottom underneath punishment is, you can see my cursor there, is a link just to take a look at some sample felonies and misdemeanors in North Carolina. So I pulled that up, and I'm just going to dodge out of the screen for just a second. I don't want to go through all of this. Of course, it's 2 pages long, but you can click on it if you're interested in this kind of thing, looking at the different classes of felonies, and you can see the maximum punishment everywhere from first-degree murder, where there's a maximum punishment of death or life without parole, Class B1 felonies, which is a type of second-degree murder, and then you can scroll on down through the felonies. So like a Class I felony would be breaking and entering a motor vehicle, possession of cocaine. You can read through those. A misdemeanor, a more serious misdemeanor is assault, inflicting serious injury or using a deadly weapon, assault by pointing a gun, all the way down to a Class 3 misdemeanor, which is hunting without a license or fishing without a license, being intoxicated and disruptive in public, and you can read about that by just clicking on the link. Okay, so coming back to our notes, let's talk about prison, because you've got felonies and misdemeanors, felonies being more serious than misdemeanors. Why do we use prison? Well, prison is there for a couple of reasons. Prison exists to separate dangerous people from society. So, you don't want people like Jeffrey Dahmer to be out in society. It's scary to think about that. It's also supposed to be a punishment, and it's supposed to be a deterrent to prevent others from committing those crimes. Of course, we could argue all day long if the prison system really is a useful deterrent. And then, most importantly, we have it there to rehabilitate criminals. So we want to take people who have committed crimes in the prison system. We're supposed to be able to help make sure that they don't commit those crimes or any other crime again once they have paid their debt to society by breaking the social contract, breaking a societal law. So they've paid their debt, and they're supposed to come out and be productive citizens. That's why in prisons, people are able to get an education and maybe even learn a trade in order to come out and to be productive citizens. Then at the bottom, I've got a quick probation versus parole. A lot of students ask about that or have asked in the past. And so probation, like we just said just a few moments earlier, you're watched by law enforcement, the courts. You don't commit another crime for a certain period. If you do, then your original punishment is going to be applied. Parole, however, is different. Parole means you are in prison. Probation is supposed to keep you out of prison, and parole gets you out of prison early if you're there. Anytime you have questions about this information, you just are curious about something, either post it in our discussion blog page, or you can email me directly if you'd like. Okay, so very quickly I want to talk about the fact that we have an adversarial system of justice. You see that as a term kind of at the bottom, closer to the bottom of your screen, right up here beyond my head. So what happens is we have two opposing sides that are working together for justice, using the exact same evidence. So we have a prosecution and a defense side in a criminal case. And so you have your adversary. Prosecution and defense are adversaries. They're kind of like enemies, but not really enemies. They're challengers. They're in opposition to each other. But the goal is to arrive at the truth using the exact same evidence. So whatever evidence the prosecution finds, they share it with the defense. Whatever evidence the defense may have, they share it with the prosecution. There's no such thing as really surprise evidence or witnesses, because what's supposed to happen is that you present this evidence to the exact same evidence to a jury of 12 people, and they're supposed to all arrive at the same conclusion. The prosecutor is the person that must prove the person who is charged guilty. It's also called the prosecutor or the district attorney, which in Cabarrus County is Roxanne Vanakoven. If you break a federal law, the court case is going to be titled the United States versus Joe Lawbreaker. If a person breaks a state law, then the court case will be the state of North Carolina versus Joe Lawbreaker. Because it's a violation of the social contract. So if you're violating a federal or state law, then of course we are going to, as a society, bring a case against you for punishment. And that's what the adversarial system of justice means. It's a very important key term for us to understand going forward in the criminal justice system. Okay, wow, your screen just exploded with a lot of information. That's because the steps in a criminal justice system is kind of complicated. But the reason it is to provide equality for all people going through the criminal justice system. So let's get started with these steps. The first step is, well, of course, a lot of people would say commit a crime, but if you didn't even commit a crime, but you're accused, you're still going to be arrested by law enforcement. That's the executive branch, because then you're going into the judicial branch with the criminal process. So that's checks and balances right there. Number 2 is booking. Once you are arrested at the police station, that's where you're going to be charged, fingerprinted, you get a photo, you can get a lawyer. A lot of students ask about when are you read your Miranda rights. Hopefully you remember that from our class discussion, and I miss you guys in class. This will be really fun to ask a lot of questions here, but anyway, email them or post them on our discussion post. But you don't have to be read your Miranda rights until you're going to be questioned by law enforcement. And the law enforcement is going to question you, of course. Your Miranda rights are going to be read to show probable cause, and you see those Miranda rights on your screen: to remain silent, to have an attorney. Of course, an attorney is also called a prosecutor, a lawyer, or even counsel. You can be appointed one if you cannot afford one, and you have the right to stop answering questions at any time. So once you've gone through that process and you're in jail, so you're waiting for the next steps, you will go before a judge, part of the judicial branch. And that's, of course, the prosecution must show probable cause for you being detained. That's habeas corpus. We've gone over that before. It's very important that you have a legitimate legal reason to be detained. The judge can set bail in the preliminary or first hearing before a judge. And you remember what bail is, right? 8th Amendment. You get out of jail until your court date, and then, of course, you get your money back. Then you can have, depending on the severity of your crime, a grand jury indictment. That's Amendment number 5. Now, sometimes people who are accused can waive their grand jury indictment if they want to just go through the process more quickly. But if you don't believe there's enough evidence against you, then you can ask, of course, to continue with that grand jury indictment. And this is where a jury of 12 to 18 people are going to hear just the evidence to see if there's enough against you to proceed to trial. If yes, then formal charges are brought against you. Formal charges are called an indictment. If not, then the suspect is released, you go home, there is no trial, and it stops there. Okay, so let's say that you have been indicted and you're going to move forward. So you've been charged. Now you have to enter your plea. So keep in mind, it kind of makes sense if you think about it. You appear before a judge. First, you can have bail set. You have to make sure that the reason that you're being held is for a legal reason. Then you have to ask, is there even enough evidence against you to proceed? If there is and you're formally charged, then you enter your plea of guilty or not guilty. Of course, you can enter a plea sometimes of no contest. That's where you admit guilt, but you're not going to admit guilt, but you're not fighting the charge either. And then the judge will set the punishment right away. Now keep in mind, if you say that you're guilty, you don't have a trial. We believe you if you say you're guilty. What if you're making it up? I don't know. We just believe you. And then, of course, your punishment is set immediately by a judge. However, if you want to go to trial, you plead not guilty. And in the arraignment process of all of these steps, that's where your trial date is going to be set. Plea bargaining is an option at this point, or really at any point throughout your trial, that the prosecution may offer a plea bargain. You can ask for a plea bargain, but it's the prosecution that really brings that to you. What they're asking you to do is plead guilty to a lesser crime so you can get a lesser punishment and avoid trial. There are positives and benefits or criticisms to this. You know, the positive is to speedily move things along so you don't clog up the trial process. But of course, the problem is sometimes people are pleading guilty for a lesser crime and they're not actually getting the justice that they deserve for the more serious crime that they committed. So there are positives and negatives to that. However, whether you have plea bargaining or not, if you're going to go to trial, we need to talk about the process there. Okay, really quickly for the trial process. Well, I say really quickly, it's going to take a minute. We're talking about Amendment number 6. Remember, everything that goes on in a trial is coming from Amendment 6. You've already had your preventing double jeopardy, which is 5. You've had your grand jury indictment, which is also Amendment 5. But your right to a lawyer and witnesses, a fair and speedy trial by impartial judge and jury, all of that is Amendment 6. What happens first in a trial once you said that you are not guilty? The prosecution is going to start with trying to prove that you are guilty beyond a reasonable doubt. So lawyers are going to pick the jury and interview witnesses. And this is part of the judicial branch, of course. So again, they have the prosecution and the defense has the exact same evidence. And they both agree on all 12 jurors to sit on the court case. So they get to what's called voir dire the jury or question the jury. Yes, if you've watched My Cousin Vinny, it's a really interesting movie to watch about the criminal process. For letter B in a trial, lawyers are going to make an opening statement. It's what they intend to prove. The prosecution always goes first because it's their burden to prove that you are guilty. I'm going to say that again. The burden of proof is on the prosecution to prove that the defendant is guilty beyond a reasonable doubt. Technically, the defense can sit there, the defendant even, can sit there and do nothing and say nothing. But, of course, they have the opportunity to present their side as well. So what happens, they start calling witnesses. And so they examine a witness. So the prosecution calls the prosecution witnesses. And during that particular stage of trial, the prosecution lawyers question those witnesses. And those prosecution witnesses are cross-examined or questioned by the defense. And then once the prosecution is all done and they rest their case, then the defense goes and they call up all of their witnesses. And all of the defense witnesses are examined by the defense or questioned by the defense attorney. And then they are cross-examined by the prosecution. So that again, everything comes out, everything's equitable and fair. Then the prosecution, followed by the defense, is going to make their closing statement. And then after they're all done, the judge is going to instruct the jury on how to decide the case. The judge is going to go over what's called the elements of the law. The judge is going to tell the jury, this person, this defendant, has to meet these specific elements to be considered guilty of this very specific crime. Then the jury is going to deliberate. And they often meet they will meet in secret to discuss the verdict. And often it takes a good bit of time. Sometimes, however, it's pretty quick. And what they do is they're going to decide the verdict. The verdict is the decision of the jury. To find someone guilty in North Carolina, it must be, you see that in red right up there, must be unanimous. All 12 jurors must agree. That's a layer of, I guess you could say, help to protect your rights as a defendant. If not, it's a hung jury, and it could be a mistrial. And so either the charges are going to be dropped, or you'll have a retrial, and that's going to be a decision for a judge to make. Keep in mind that this jury that I'm talking about, that's the petite jury, not the grand jury. The petite jury is someone who's totally different, these 12 different people, and they decide your guilt. Remember that the verdict is either guilty or not guilty. They never say innocent, because what they're saying is that either you are guilty of this specific crime with all of the elements that's part of that crime, or you're not guilty. So you could be guilty of murder, but if you're charged with first degree, and the prosecution can't prove that you're guilty of first degree murder by premeditating it, you can't be found guilty. They can't say, well, you know, we the jury are going to say you're not guilty of first degree murder, but it's probably second degree. They can't do that. And they're probably not going to put you on trial again, the prosecution won't, for second degree murder, because it looks like they're just trying to pin a charge on you. So if you are found not guilty, we call that acquittal. That's a key term. I probably should have highlighted that, but acquittal is an important key term. And then you're sentenced by a judge according to North Carolina's structured sentencing. We'll take a look at that in just a second. And the structured sentence looks at the type of crime and your background, but you do have the right of an appeal. The only reason you would get an appeal is if your rights were violated. When we go over the level of the courts after spring break, we'll talk about what that looks like. How can you get an appeal where you can get your case heard again? And last, I want to talk about recidivism, that last word there, to repeat criminal behavior. So oftentimes when we look at people who are in prison, a lot of times when they get out of prison, then they're going to repeat that criminal behavior. Most people who are in prison have some sort of background of committing crimes, and we call that, again, recidivism. And if you go to nccourts.gov, or you could even Google search for North Carolina structured sentencing, this is an example of a felony punishment chart. So what they do, if you can see my cursor on the screen, when you look at a felony class A, and then you earn points, of course, for the severity of the crime and your background. And so they use this matrix to look at the minimum, which is actually months, not years, months in prison to the maximum months of prison. And you can see that through all classes as I scroll down of felonies, even through Class I. So you look at kind of the lower 6 to 8 months down here, 3 to 4 months over here. Okay, just like before with the sources and types of law, we're going to do another Quizlet practice. I hope you liked it. But if you'll join our Steps to a Criminal Case Quizlet, you'll see the link on your screen. It's also going to be linked in Canvas for this assignment page. Again, please review the terms with the flashcards, then if you'll take the test. Your responses are going to be recorded in Quizlet, so you will not need to submit anything to Canvas. But you will need to complete this assignment by Thursday, April the 9th at 3:00 p.m. So again, when you go to our Drake Civics 2019-2020 Quizlet page, then you go to Steps to a Criminal Case, because you already did the one down here, Types and Sources of Law. You click on that. There's 21 terms. Go through there, and of course, flip it over. Make sure you know what the terms mean. This is a very important unit for terms. You can play some of the other games if you'd like, but I'm looking for the test. So you click on Test, and you'll go through the written questions, the matching questions, multiple choice, and finally true/false. And then you can check your answers. And I can't wait to see how you guys do. If you have any questions, send me an email. I hope you guys have a good week. Bye-bye.